Takeover. The poison pill. The poison pill is a takeover defense used by publicly traded companies to discourage unwelcome acquisitions by making the stock less attractive to the acquirer. There are several ways of achieving this. You have the flip-in, which allows existing shareholders except the acquirer to buy more shares at a discount. The flip-over, which allows stockholders to buy the acquirer's shares at a discounted price after the merger. Issuing convertibles, which below market exercise prices whose conversion is triggered by a takeover. You can also make employee and director share options, which would normally be exercisable in the future, immediately exercisable upon a takeover. And lastly, you can have agreements with customers that include compensation in the event of a takeover. The poison pill is intended to make the takeover so expensive that any attempt to take control will be abandoned. Poison pills are designed to protect directors and are harmful to shareholders. Poison pills are designed to deny them the opportunity of selling to an acquirer, usually at a significant premium to the price, without bid interest. Shareholders and regulators have become less tolerant of poison pills, and they have become more rare in most major markets, although Japan appears to be lagging in this respect. Hi, you're still here. Then we need to speak about power of attorney, proxy, attorney in fact, proxy statement. A power of attorney is a written authorization for one person to act on behalf of another. The person granting the power is called the grantor, and the person authorized to act is the agent or the attorney in fact. The power granted by a power of attorney can be quite broad in scope and may include the power to sign documents on behalf of the grantor and deal with other financial and legal affairs of the grantor, but it can also be quite narrowly tailored. Some examples of power of attorney in use. I hereby exercise my authority under the power of attorney, and the power of attorney was revoked. In the context of company law, when a person is authorized to vote the shareholders' votes at an annual meeting of shareholders or other general meeting of shareholders, that person is typically called a proxy, not an attorney in fact. So a proxy commonly refers to authorization to vote on another's behalf and is therefore more limited in scope than a power of attorney. And proxy can refer either to the representative of the grantor who is authorized to vote on behalf of the grantor, or the written authorization to vote on behalf of the grantor. Some phrases using proxy. Britons may continue to vote by proxy for up to 20 years after they leave the country, and management which control the voting process win most proxy battles. Proxy fight is synonymous with proxy battles, and that's basically a contest between two or more opposing sides in the process of soliciting proxies from shareholders. A proxy holder is of course the person who is authorized to vote on behalf of the shareholder, and a proxy statement is the written material given to shareholders about qualified. Qualify has several meanings. The first one, best known one, is to provide with the necessary skills, knowledge, or credentials. So, for instance, I like to think that I'm well qualified for my job as a lawyer linguist because I have a bachelor's in linguistics and a law degree. We can also say in the UK, law students then qualify as a solicitor after they have achieved all of the necessary knowledge by taking courses and the appropriate tests to become a solicitor, and then the law society admits them because they have appropriate skills, knowledge and credentials. A qualified voter is one who meets the necessary residence, age and registration requirements for voting. Important meaning is to limit or to restrict, so we would say, for instance, the general rule is qualified by exceptions. We often talk about a qualified majority, which is a majority which is larger than the usual 50 or 51% majority. In some cases it's 60%, in some cases it's 75%, and in fact qualified majority voting is the most common form of voting in the European Union Council of Ministers. In that case it requires 345 votes, but as you understand, the qualified majority is some sort of exception to the normal majority rule. We also talk about, for instance, an unqualified legal opinion. By that we do not mean an opinion which is given by a bad lawyer, but we mean an opinion which has no exceptions or reservations or exemptions. We also have the noun form qualification, and that has both of the same meanings that the verb does. For instance, we say that a general rule has no qualifications if it's an absolute rule, and as I like to say about myself again, I have all of the qualifications needed for my job. Thank you.